Let me show you what's 516. I'm sorry, it's 516. Does that also appear to be a photograph that was taken on the 17th, Doctor?
I think so. I think so, from the surroundings.
Now, Doctor, do you see on the lateral side of the wrist what would be the ulnar side, I believe? Do you see what
May I
appeared?
see the notes that that you took back? That'll
Sure.
help me.
And I'm giving the doctor back my copy because I think we
Yeah.
still have it for the Elmo. I'd like it back on the Elmo, please.
What I refer to in my notes that is on the medial aspect of the wrist, and when I say medial aspect, it's the pinky side of the wrist, the side into the body in the anatomic position. I have here a ½ inch in front of the wrist and 3/8 inch back of the wrist. Would be the what appear to be abrasions that are shown on this photograph that you just showed me.
You don't list them as abrasions, do you, Doctor?
It says wrist, medial aspect, ½ inch distal to wrist, 3/8 inch proximal to wrist. And I will have the original of this waiting for me at the hotel when I come back to see if anything was left out. But in my opinion, I was referring to the abrasions.
My question is, sir, did you use the word abrasion?
It's not here on this Xerox copy.
Now, sir, did you appear on NBC Dateline on June 23rd, 1994, regarding your observations of that hand of Mr. Simpson's, the left hand?
Yes. Is this a Burrell's transcript?
I'm afraid I'm not familiar with the company, Your Honor. Through our media relations, I've been provided with this.
This appears to be a whole segment. And
What, are you just focusing on one particular
Absolutely, and I
passage?
showed Mr. Shapiro which area I was focusing on.
just to make sure it's in proper context, may I just have a few moments? I don't want to
Sure.
interrupt, or maybe...
Take your time.
Thank you.
Yes, with court clerk, please. All right, thank you, counsel. Proceed.
Thank you, Your Honor. Dr. Baden, did you in fact appear on a Dateline NBC program June 23rd, 1994, in which you were asked about your examination of Mr. Simpson's left hand?
Mr. Kelberg's entitled to lay the foundation under 770 as he chooses. Proceed.
I don't specifically recall, but if you have that date, I would agree with it, I guess.
Doctor, on that program, were you asked by a reporter by the name of John Larson whether on the 17th of September you looked at the cut hand of Mr. Simpson, and did you give the following answer?
17th of June?
Yes, that your examination was on the 17th.
Of June, you said
Yes.
September.
Of June. I'm sorry if I
Okay.
misspoke. Your answer, I looked at the injury. There was very whatever cuts. I think saying cuts gives it a magnitude it doesn't have. They were tiny little marks on the body, on the hands. And then the question from the reporter, could they have been the result of a struggle? And your answer, they could, may or may not be consistent with a struggle. Certainly it is not consistent with a lot of struggle. I mean, there's no other marks on the body. Did you give those answers to those questions asked of you by a reporter?
I do not have an independent recollection, but I would agree with what you say. I mean, I have no reason to say what you're reading to me isn't what I said.
Sir, in that, you never mention any abrasions being seen, even the two that you indicate may be reflected by this lower entry on your form, correct?
It's argumentative. This is a cut and paste interview.
You may answer the
From what you
question.
read to me, I didn't say anything about abrasions, and I agree with you. I think that my mark, that wrist that's on the elbow, refers to two abrasions, yes.
Doctor, in your answer here, were you trying to minimize the significance of injuries that you had seen on Mr. Simpson's left hand on June 17th?
I don't think so.
Well, in fact, sir, you testified that these were cuts, correct?
You mean,
Here in trial, you testified they were cuts that you observed. Isn't that correct?
yes.
You said on the interview, I think saying cuts gives it a magnitude it doesn't have.
Well,
Were they cuts or not, sir?
I think that there are two cuts.
Overruled. Overruled. Have a seat.
I think I called a laceration on the back of the third finger, not a cut, a laceration, and cuts on the inside of the two hands, of the two fingers. But I'd like to, if I might, could I see that in context, because I was responding to whatever the situation was at the time. I'm not there to give a full medical workup to the media, but
Well, doctor, you were not obligated to talk to the media, were you, Dr. Baden?
that's correct. I am not obligated to talk to the media.
You could have told the reporter to go pound sand, that you've been retained by the defense, and it's a privileged communication between the client, Mr. Simpson, and an expert retained by the lawyer, Dr. Baden.
I could always refuse to talk to the media, certainly.
But you didn't, did you?
I did not.
Would you show Dr. Baden the
Sure.
transcript that you're referring to, please?
Sure.
Dr. Baden, feel free to take a moment and see if the context is appropriate.
Yes, it's hard to get it in context because there are voiceovers and there are many different people talking, but I think what you quoted me saying is, sounds accurate.
Now, sir, was it your opinion that those injuries could have been the result of a struggle between Mr. Simpson and another human being?
I think that's what I said, and I would have to agree with it.
Now, doctor, you also said, in response to a question from Mr. Shapiro, that the source of the cut on the middle finger of the left hand was more likely from glass. Is that correct?
Yes.
But in your opinion, sir, could it have been caused by a knife, a sharp-edged knife?
It could be, but that's not my opinion. No, my opinion is it could be, but very unlikely, because a sharp knife would not cause as jagged a cut. And may I see the what I said there, please, once again?
see what you said.
What you quoted, yeah, because I think I misspoke just a moment ago. What I said on the program was they could, may or may not be consistent with a struggle. It is not consistent with a lot of struggle because there are no other marks on the body. So the only place I saw injury was on the hands. He had a lot of injury, a lot of old healed injuries on his body from previous. So it could or couldn't be a struggle, but I can't exclude a struggle, but it didn't look like a significant struggle, is what I was trying to convey, and there were small cuts on the inside of the fingers.
Were those cuts consistent with a sharp knife, sir?
Yes, could be the edge tip of a sharp knife. I can't exclude that.
Doctor, did you ask Mr. Simpson on the 17th when he received any of the injuries you identified in your examination?
See counsel at sidebar with clipboard, please. All right, thank you, counsel.
Let me re-ask the question, Doctor. Did you, on the 17th of June, ask Mr. Simpson when he received any of these injuries?
Yes, I believe I did.
And what was his response on the 17th of June with respect to when he received any of the injuries?
His response was that he received cuts on his hand and on the third finger, on the knuckle, in Chicago, the 14th, I guess, on June 14th, just before he returned to New York, and that he may have cut himself on his fingers before he got in the airplane while getting his stuff together, but he didn't really know because he cut himself very frequently. He had and he did have a lot of nicks and bruises that were old and healed up.
Did he say to you, sir, that he received any of those cuts while he was still in Los Angeles on the 12th of June in preparation to go to the airport for a trip to Chicago?
Yes, that he had cut himself. He wasn't quite sure how he cut himself. And noticed he had been bleeding, but didn't know how it came about in his home, someplace in his home in Rockingham, before he got onto the airplane going to Chicago.
And which cut or cuts did he refer to as receiving before leaving his home on Rockingham to go to the airport?
My interpretation was...
I'll move to strike, Your
What?
Honor, as non-responsive.
Overruled.
Yeah, my interpretation was that one of the cuts on the distal inside of the fingers, the third or fourth finger, not the one on the knuckle. The one on the knuckle, he clearly recalled cutting himself in Chicago before coming back, I guess on the 13th, not the 14th, and that he had a cut on the inside of one of the fingers, which he didn't even realize had happened until he saw some blood coming out of it.
Is that what he told you, or is that what your interpretation is?
That's the best of my recollection. I didn't tape record it.
Now, Doctor, did you ask him on the 17th how, the mechanism, the manner in which he got any of the cuts you observed?
Yes.
What, if anything, did Mr. Simpson have to say as to the manner in which he got the cuts?
That he recalls some blood after trying to retrieve his phone or some material from the Bronco, from a car that he had his phone. I think it was the Bronco. That he'd gone to the Bronco to get something and may have somehow cut himself while getting stuff from the Bronco to bring with him to Chicago.
And what, if any, explanation did he give for the cut to the middle finger?
The knuckle and middle finger was that he broke a glass in the hotel room in Chicago after hearing about his ex-wife's death.
Now, doctor, as a forensic pathologist, by training, do you usually treat with some suspicion self-reporting made by possible suspects in crimes?
Sustained.
Doctor, did you accept Mr. Simpson's explanation as the truth?
Sustained.
May I be heard on that, Your Honor?
Sustained.
Doctor, the injury to the middle finger that you say Mr. Simpson claimed was due to glass, did he show you how you could get a cut along the middle finger, the back of the middle finger, by having some involvement with glass?
Well, he said to me words to the effect that after hearing the news by telephone, he was at a sink or something and squeezed and broke and banged the glass against, as I recall, the sink top right next to the faucet, right next to the sink faucets, and somehow cut his back of his finger from the shattered or the broken glass.
Did you see any cuts to the palm of his hand?
No, his palms of his hands had no cuts, as I recall.
Did you see any cuts along the edge where the pinky finger is?
No, I had the, you have the photograph showing the scrape marks on the inside of the wrist at that area.
Those are not cuts, are they, sir?
Well, they're scrapes. They're not cuts, they're scrapes.
And that is something that is consistent with, for example, Mr. Goldman scratching or rubbing across that area of Mr. Simpson's arm if Mr. Simpson had Mr. Goldman from behind with his left arm as Dr. Lakshmanan demonstrated. Isn't that correct, sir?
Evidence calls for speculation.
Oh, well.
No, I think that whole demonstration with Dr. Lakshmanan I have difficulty with, and I think that because it's purely speculative, but there are many ways in which one can scrape the inside of the wrist, and it could have happened on Monday, on Sunday, on Saturday, on Tuesday. There's no way of dating when it happened, except that it was healing when I saw it.
My question to you was, assuming that Mr. Simpson did have Mr. Goldman, as Dr. Lakshmanan demonstrated, with his left arm around the chest of Mr. Goldman, his right hand holding the knife at Mr. Goldman's neck, making those two parallel superficial incised wounds, is it consistent with what you see as the abrasions along this area of the wrist, that that can be caused by Mr. Goldman's effort to free himself from that bar arm hold?
That's not my opinion. I don't think it's consistent with that.
Doctor, how, in your opinion, can somebody get a cut on the back of their middle finger from slamming a glass down without having cuts or other injuries in the palm or pinky or fourth finger areas when the glass is slammed down, if in fact that ever occurred?
If the glass is slammed down and there are broken shards of glass, a piece of glass, and the individual tries to move it aside with the back of his hand. People can get cuts on the back of their hands from broken glass. I mean, they're not grabbing the cuts, they're shaving into the sink, because I did see photographs from Chicago of glass in the sink, and if he were to have moved the glass with the back of his hand, it's possible to cut himself?
Did he ever tell you he moved the glass with the back of his hand and that's how he cut himself?
He told me he didn't, he was so disturbed he didn't recall exactly what happened, except that he cut himself. And then there was blood on the sheet next to the telephone, which gave support to that.
Your Honor, I have a series of photographs that counsel has seen. They were provided to counsel.
No, we've gotten thousands of photographs.
No,
These are the Chicago photos.
because they,
Your Honor, may they be marked, I think we're at 581A through whatever the last appropriate number will be, letter.
letter, A through whatever. So we'll need to mark them so the record will reflect which one we're referring to.
I will, Your Honor. I'm going to mark them as I get to them. May I approach? Doctor, let me show you what I'll first mark as 581A, and it has a designation already, number 16 in the upper left-hand back corner.
Yes, sir.
Do you see that?
Yes.
Is that one of the photographs you looked at?
Yes.
Let me show you a second one. Ask that be B, and it has the number 1 in the upper, what would be the lower right hand as one looks at the photo. Did you look at that?
Yes.
Yes.
And C, another photo, this one has the number 5, so may that be 581C.
Yes.
Mr. Douglas says, was keeping track of our exhibits, asked that if they may be described a little better for sake of keeping our records.
Well-
Appreciate it.
We'll make that available to Mr. Douglas at the conclusion of the court day.
As D, the photo that has the number 8 on the back.
Yes.
This is A, 581A.
All right, it appears to be a photograph of a sink with what appears to be glass in the drain area.
Doctor, assuming that this is a photograph taken in Chicago, after Mr. Simpson had been notified by the Los Angeles Police Department of the death of Nicole Brown Simpson, and that the room was secured at some point after that call, and found in the sink was what you see in this photograph.
Yes, sir.
Do you see what appears to be any blood on any aspect of that glass?
No.
And showing you the balance of the photographs, I don't know how closely you had an opportunity to look at them. This is B, showing the sink area and the floor. Do you see, at least on the sink area, what appears to be blood anywhere?
No, I don't see any suggestions.
And this is, I believe, this is the one that's marked number 5. I believe this is C, showing the left side of the sink with a partial picture of the glass. Do you see that?
Yes.
And again, do you see any evidence of blood?
No, I do not.
I've got one more. Just mark 4. Well, Dr. Baden, I'll be glad to show you the front of the hotel, if that will be of any assistance to you, but I don't think it will.
No. Counsel, he gets to conduct his examination and show what he wants. You can do whatever you want and redirect.
We have the last photo. Oh, did I only give you 3? I'm sorry. And now a photograph showing the right side. Do you see that?
Yes, sir.
And again, the question, do you see what appears to be evidence of blood?
Not in those photographs.
Now, doctor, if the glass had been slid across into the sink and a cut had been incurred in that fashion, would you expect to see some smearing of blood along the surface where the action is taking place?
Might if the bleeding started right away, and if it weren't washed off in the interim, afterwards.
That's a very vascular area, this area of the middle finger around the knuckle. Isn't that what you said?
I didn't say that, but the hand is vascular, and the knuckles are vascular. One bleeds from that kind of a cut, and I would expect him to bleed pretty quickly. I don't know. These photographs were obviously taken many hours after the incident, so I don't know.
How do you know that, doctor?
Because I assume there was no cameraman in the
I'll move-
hotel in his room when he did this.
I'll move to strike, non-responsive.
Overruled.
Doctor, you have no personal knowledge, do you, as to when these photographs were taken in relationship to the injury allegedly being incurred with a broken glass? Correct?
I do have some knowledge that these
You
were
have no-
taken after he checked out of the hotel.
You have no personal knowledge?
No personal knowledge.
And you don't know when an inspection of that room took place in relationship to when Mr. Simpson checked out of the hotel, do you?
That's correct.
And you don't know if during that inspection, this was the condition that the room was found in and it was secured for the police to arrive. You have no personal knowledge to
That's
dispute
correct.
that either,
That's
do you?
correct.
Doctor, by the way, did Mr. Simpson tell you when he went out to the Bronco to get the phone and allegedly cut himself possibly on that area, fourth finger?
He told me that while preparing to go to Chicago, at some point he went to the Bronco to get the phone and maybe other material, and he also did things around the house and the kitchen, and at some point he noticed some blood, but from it coming from his finger, but this was shortly before he left for Chicago.
Doctor, at the time you talked with Mr. Simpson on the 17th, had you been apprised by listening to anything or seeing anything indicating that Mr. Simpson's blood had been found in the Bronco and at his Rockingham home? Found by police?
I don't recall. I don't recall what I knew at that time. I had not known. I doubt it. I doubt it because I didn't know too much about it, about the death and the investigation until I came into Los Angeles at Mr. Shapiro's request, and that was just a few hours, the evening before Dr. Lee and I came to Mr. Kardashian's house to examine Mr. Simpson. So I don't know what I knew at that time, Mr. Kelberg.
May I just a moment? Doctor, you were in communication with Mr. Shapiro between the 14th and the 16th when you arrived, correct?
Yes.
And did you ask Mr. Shapiro at any time during the course of those conversations, basically what was the status of the police investigation?
I'm going to sustain the objection to that.
I'm going to move to a different area. And, Your Honor, are we going to 5, is it? 5. Okay. Doctor, you talked about the stomach contents. Do you recall your testimony in that regard?
Yes, Mr. Kelberg.
And would you expect that Dr. Golden's description of Nicole Brown Simpson's stomach contents would not be a difficult task to do? That is, a trained forensic pathologist can examine stomach contents and identify, sometimes by the naked eye, what the contents are.
Yes, that can be done.
Now, sir, Dr. Golden identified rigatoni, correct?
Yes.
He identified black olives.
He, in the report, it says rigatoni and spinach leaves.
And did you hear the testimony?
And then the tape, some tape, he said black olives that isn't included.
But on the dictation, he actually included black olives, right?
That's, yes,
And a leafy material that appeared to be like spinach, correct?
yes.
Doctor, did you ever contact people at the Mezzaluna restaurant to see what was served that night to the Brown-Simpson party?
I made inquiries, I didn't call Mezzaluna restaurant, but I asked, discussed that with Mr. Shapiro about finding out that information.
And did you find that, in fact, there were pasta dishes served which come with rigatoni?
Sustained. Rephrase the question.
Doctor, did you receive information that Nicole Brown-Simpson had rigatoni?
Sustained.
Did you hear the testimony of Tia Gavin, the server?
No,
If she testified that she had heard, after the incident, from talking with the other employees, that Ms. Brown-Simpson had rigatoni, number one, would that refresh your memory of any information you received in that regard? I have the
Sustained.
transcripts here, Your Honor. I'd like to be heard.
Sustained.
Referring court and counsel to pages 13568, 13568. I'm sorry, with or without?
Without. All right, thank you, counsel. Rephrase the question, please.
Doctor, I want you to assume that Tia Gavin testified as follows in this case, and referring court and counsel to 13568 and 13569, starting at line 18. Question, do you have any independent recollection as to what Nicole Brown-Simpson had for dinner that night? Answer, no, no. Question, do you have any way of refreshing your memory as to what she had for dinner? Answer, only discussions that happened after the event. Question, discussions with who? Answer, people in the restaurant, employees, fellow employees. Question, and did that refresh your memory as to what she had for dinner? Answer, yes. Question, and well, what did they tell you? Answer, rigatoni. Doctor, assuming that that testimony was given, would Dr. Golden's findings in the stomach contents of rigatoni tend to support the accuracy of Tia Gavin's testimony as to what Nicole Brown-Simpson had?
Rephrase the question.
Doctor, assuming Dr. Golden had no information at the time of the autopsy as to where Nicole Brown-Simpson had eaten dinner on the 12th and what she had had for dinner on the 12th, and he identified rigatoni in the stomach contents, along with a leafy material, apparently like spinach, and black olives. Would that be consistent, sir, with the testimony of Tia Gavin?
Sustained.
Doctor, the menu, did you ever see the bill from Mezzaluna that showed the entries?
No, I did not.
Mr. Kelberg, isn't the issue whether or not that testimony by Tia Gavin would have any impact on Dr. Baden's testimony here about the presence of rigatoni in the stomach contents as it relates to the time to digest and the time of death? Isn't that the issue?
It's certainly part of the issue, Your Honor.
All right, why don't you
I'll
ask
do
him
it-
that
I'll do it
question?
a different way.
All right.
Dr. Baden, you said that rigatoni as a pasta will break down from its identifiable condition within a half an hour?
Yes, usually within a half hour, maybe a little longer, depending on how much is eaten.
What research are you relying upon, if any, to support that view?
Studying stomach contents at every autopsy for 30 years.
Well, sir, if you study the stomach contents, you would have to know, A, the exact time of death, correct?
Not necessarily, Mr. Kelberg, because especially with pasta-like materials, the stomach can keep breaking down the materials after death. You see, there's a certain amount of digestive juices in the stomach that keep acting even after a person dies.
Well, doctor, you would need to know then, number one, when the person ate the alleged pasta, right?
Okay, yes.
Where are your studies, if any, have been done that show how you have correlated actual times of eating pasta with identification of stomach contents?
I haven't published any studies along those lines, but this is ordinary medical examiner daily work.
Sir, is it your view that the stomach normally empties within 2 hours of the time of eating?
For a normal meal, 95% of a meal in a healthy person will empty within 2 hours. Yes, sir.
Are you familiar with the Bent case, B-E-N-T case?
Yes.
And that's a case where the prosecution in Albany, New York, retained your services on a possible murder of a woman, Joan Bent, correct?
Yes.
And in that case, Joan Bent had been missing for about 11 days when her body was found in the trunk of her car, correct?
Yes.
And her body was basically in a frozen condition given the cold temperatures at the time of these events. Isn't that correct?
Yes.
Her husband had given an account to the police reporting her missing, in which he said that they had been together about 4:30 for dinner, correct?
Relevancy grounds at 352, we go through the whole case, which took a long time to try and hold.
Correct? Told the police they had dinner about 4:30?
That sounds correct, yes.
And that his wife left about 6:30 in the evening for business, right?
I will accept what you're saying. I don't remember the exact timings on it.
Doctor, and you formed an opinion based upon the contents of potatoes in the stomach that the husband had lied to the police because the form of the potatoes was such that it would have to have been death within about an hour at the most of the meal being taken in by Mrs. Bent. Isn't that correct?
Yeah, that was part of my evaluation. That is that the knife cuts, serrated knife cuts on the potatoes, which were swallowed and not chewed, were still identifiable.
And in the course of your testimony in that case, I'm sorry? I'm just going to get it first before I'll be glad to. In fact, I'm going to use a report first. Thank you, Your Honor. Doctor, your view is that in general, 95% of the contents of a stomach will pass from the stomach within 2 hours of eating, correct?
In a normal meal, yes.
And a normal meal in the Bent case included a meal of 1,000 cc's, right?
It was pork and potatoes, I remember. I don't remember the volume.
Wasn't
But I
it-
do remember they were intact potato, sliced whole potatoes with, I believe, serrated edges on some of the potatoes from the knife.
Doctor, are you relying on any research for your position that the stomach empties within 2 hours, 95% of the stomach empties within 2 hours of eating?
From personal experience, from studies done by giving people barium meals, that is, the radiologists commonly, or used to in the old days, before CAT scans and all, would give patients barium meals and then x-ray the meal to see how quickly it emptied. And my experience and readings, yes.
You were here for Dr. Lakshmanan's testimony regarding stomach contents,
I was.
and you heard him testify about the Belandi study, which was a study using ultrasound to see how a pasta meal went through a person's stomach.
I have a vague recollection. Incidentally, I don't believe I was here every day for Dr. Lakshman. Either I or Dr. Wolf were here. So I don't specifically remember that.
But if you missed it, Dr. Wolf was to fill you in.
Yes.
If Dr. Lakshmanan testified regarding the Belandi study that a pasta meal took 248 minutes, roughly 4 hours, to pass, that would be inconsistent with your opinion about a pasta meal such as a rigatoni meal passing within 2 hours. Isn't that correct, sir?
No, it isn't inconsistent because it depends what you mean by the meal passing. What I'm talking about is the bulk of the meal passing.
95%?
Because, yeah, approximately 95%, because the stomach in a normal person has little grooves in it, what are called rugae, and food often gets trapped so that things that we eat can still be in those grooves 24 hours later. But the great bulk of the meal will normally be out of the stomach in about 2 hours.
If Nicole Brown Simpson finished eating at the Mezzaluna restaurant a rigatoni dinner with a salad and left that restaurant between 8:30 and 9, a quarter to 9 as one witness testified, and stopped eating sometime before she actually left the restaurant, sir,
That's the usual way, yes.
and then did not have any additional rigatoni, did not have any additional salad, based upon your view of how the stomach empties, sir, what time of death would you give for her murder?
Objection on 2 grounds. Number one, that she had a rigatoni dinner. And number two, that it assumes facts not over.
I have a problem with your question because it depends how much she ate. At the time of her death, 2 hours, somewhere around 2 hours later, according to your theory, she had a half a quart of food in her stomach. That's a huge amount of food. So if you're asking me to assume that she didn't eat anything after she left the restaurant, that's a big assumption. I'll assume what you're asking, but then she would have had a huge amount of food at Mezzaluna restaurant, assuming she was a healthy person, had normal digestion.
Doctor, if you testified in the Bent case that 1,000 cc's was the content of Mrs. Bent's stomach and that constituted a heavy meal, and if we assume that Dr. Golden found 500 cc's in Ms. Brown Simpson's stomach, and that is in fact what his report indicates, isn't it, sir?
500 cc, yes.
And you would describe that as at least a medium-sized meal?
Well, it's the remnants of a bigger meal.
But
Oh,
just the
big one.
quantity of 500 cc's is certainly equivalent to a medium-sized meal?
Medium to large.
And doctor, assuming that she had her rigatoni and her salad at the restaurant, maybe went for ice cream, but didn't have rigatoni, didn't have salad after that, what would you estimate the time of death to be, given your view that 90 to 95% of the stomach contents is gone within 2 hours of the meal being eaten?
As I recall my opinion, the Ben case
I'll move
that
to
you're
strike
referring
as
to,
non-responsive. Doctor, that hypothetical I gave you, my question to you is your opinion in this case as to the time of death for Nicole Brown Simpson given that hypothetical set of circumstances.
leaving out the Ben case, because that, you made an improper comparison, leaving out the Ben case.
Your Honor, I'm going to move to strike as non-responsive.
You can answer the question. You're asking him to give expert opinion based on hypothetical set of circumstances. Stated, which does not include benefits.
Okay.
My opinion,
All right. Thank you, Your Honor.
my opinion would be that if she had 500 cc or milliliters of food in her stomach with recognizable pasta, rigatoni, having eaten before 8:30 p.m., that it doesn't make sense that she could have lived for 2 hours after that meal. She must have eaten a huge amount more than that, because most of it would have. She was alive at around 10-ish, I guess, when she had a telephone conversation. So an hour and a half, for example, after eating that meal, a great portion of it would have had to have gone out of the stomach, so it would have had to start out much greater than 500, and there would have been more digestion of the rigatoni, making it very difficult to identify. I don't know how intact the rigatoni was. Maybe Dr. Golden is very good at this stuff and can get a little fragment of a pasta and identify it.
Did you ask him?
I spoke to Dr. Golden, but he, not on this matter.
Did you ask Dr. Golden, sir, how he identified the condition of the rigatoni?
No. However, that's why other people have to be able to look at it. That's why it should have been saved, because the degree of digestion of the rigatoni would be very important. And I think my view would be that if she stopped eating before 8:30 and has this in her stomach at 10 o'clock, that she ate in between.
Doctor, did you, I'll withdraw the question. Doctor, would it be your opinion that the more recognizable the rigatoni, the shorter the interval between the time she last ate and the time she died, assuming she did not have rigatoni after she left the restaurant?
Objection, it's an improper assumption based on the doctor's answer.
Yeah. The more intact, see, I can't see with, I
I'm
don't.
going to move to strike as non-responsive.
No, I'm trying. The more intact and the more recognizable the rigatoni is, the less digestion there is of the rigatoni, that they're all intact tubes, the closer the death is to the time of eating.
Now, doctor, did you hear or review Dr. Lakshmana's testimony, if you were not here, in which we reviewed what the literature says, for example, Knight's book on stomach emptying as a measure of time since death?
I was here when you went through a lot of time of death information.
And did you hear at that time from Dr. Knight's book on page 82, it was assumed that the physiological process of digestion...
May we also have an opportunity to see this before?
This was used, Your Honor, on direct examination of Dr. Lakshmana. Thank you. It was assumed that the physiological process of digestion of an average meal lasted some 2 hours. This is based on the consumption of a test meal of a gruel. Hardly a representative example of a modern mixed diet. Moreover, the subjects of experimental work were healthy and presumably free from sudden stress during the experiments. More elaborate descriptions of digestive times of various foods have been drawn up, but they are of dubious value. As an example of the great variations offered, Modi, M-O-D-I, gives 4 to 6 hours for a meat and vegetable meal, and 6 to 7 hours for a farinaceous meal. Adelson, and Adelson's book is Pathology of Homicide, is it not, Doctor?
Yes,
You're familiar with it?
yes.
Adelson stated that the stomach begins to empty within 10 minutes of swallowing, that a light meal leaves the stomach by 2 hours, a medium meal takes from 3 to 4 hours, and a large heavy meal takes 4 to 6 hours. Recall hearing that from Dr. Knight's book.
I read that in Dr. Knight's book.
You disagree with his view that it is not appropriate to say that the stomach empties within 2 hours. Correct? You disagree with his view.
I agree with some things and not with other things. A great deal has to do with just deciding how much volume of food and what kind of food is taken in. But my experience has been, and the experience of others, even Dr. Knight has this wide variation, is that in a normal, healthy person, not under stress, as indicated, 95%, the great bulk of the meal will empty in 2 hours. That's the way it works.
If you testified in the Bent case that 1,000 cc's was a heavy meal, then 90 to 95% emptying would leave roughly 100 cc's?
Oh, in the Bent case,
Excuse
my
me.
opinion was that the death
I'll move the
occurred
strike. I'm
almost immediately after she ate.
If the stomach contents had passed under your 2-hour theory, she would have had about 100 cc's if death occurred after that 2-hour period, right? Using the 90 to 95% rule that you have.
Except that 1,000 cc is a huge amount. That's much more than the average meal. That's a quart of food in the stomach. So, but in the Ben case, my opinion was, as I recollect, that she died very quickly after she ate. He didn't wait around 2 hours to kill her.
Well, doctor, if 500 cc's is found in Nicole Brown Simpson's stomach, and that represents 90% passage of a meal, how much would have been in her stomach?
A huge amount when she ate at Mezzaluna. That's why looking in the refrigerator and looking in the garbage and looking in the sink is important to a medical examiner, to see what foods were eaten at the house, at the scene of death.
And doctor, isn't that why you've offered those explanations? Because you realize that using your theory of stomach emptying means that the time of death for Nicole Brown Simpson is closer to 10:15 than it is to 11 o'clock. Isn't that your change of view to looking in the stomach, looking in the refrigerator, looking in the garbage can, and so forth? May I briefly, Your Honor, 2 photographs that have been previously marked 75 and 76?
I think we're going to call it a day.
Okay.
All right, please. As far as the jury is concerned, we're going to take our recess for the evening. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't have any deliberation until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. Have a pleasant evening. See you tomorrow morning at 9 o'clock. Dr. Baden, you may step down. Your order to return tomorrow morning at 9 o'clock. Thank you. All right. The jury is not present. We have 2 matters to take up. First is the matter of the items that have been subpoenaed and delivered to the court. I'm about to clear the courtroom. All right, let's take up the issue of the first dibs on the material that is subpoenaed to the court.
Yes, thank you very kindly, Your Honor. I'll be brief. The hour's late. The court, I think, is somewhat aware of the facts, but I'd just briefly like to indicate the tapes which were turned over this afternoon
are tapes which I went to North Carolina, pursued through the North Carolina Court of Appeals, and then asked to be brought here. They are copies of the originals. Pursuant to the order of the North Carolina Court, those tapes will be turned over to the petitioner's counsel, myself. Mr. Simpson paid for the copies of those tapes, paid for the reproduction of those transcripts. The district attorney's office had nothing to do with this at all. What happened was, according to Messrs. Regwan and Schwartz, who have fought vigorously on behalf of their client, they were summoned downtown yesterday by the DA's office and given a subpoena ducis tecum, according to them. And they came pursuant to that. But these tapes, by my previous arrangement, once we won in North Carolina on Monday, I made arrangements in talking to Ms. McKinney, because she'll still be coming to California with the originals for this court, to pay for these, to have them brought out, because the court is aware we're going to have, I'm very concerned about security of these things, and we made arrangements to have these brought to us so I could then check the actual transcript that accompanies these tapes, and they would be put in a safe place, and they would not be leaked. Mr. Simpson paid for those, as he'll be paying for the witness when they come to California. In fact, I need to remind this court, when I asked this court for a further declaration, the prosecution objected and said you couldn't do this, and we were the ones arguing full faith and credit. We were the ones who stood up for this court. Those are our tapes. They have nothing to do with these tapes. If they want to pursue them, let them pursue them. This is impeachment, and as I just was reminded in the course of Mr. Kelberg, as he would run up there with all these transcripts and things and try to impeach Dr. Baden, we get to see him at the very last moment. We will, at the appropriate time, if they want to make motions, they'll be available to them. But this sneak attack of trying to go and subpoena the lawyers for the tapes, which we have now been given custody of by the North Carolina court, we have paid for, is just not right, Your Honor. And so what I'm asking is that the court turn those tapes over to me right now. They would have been turned over to me this morning at 10 o'clock. And by now, I would have had a transcript under seal for this court. I have in a 1054.7. Well, you know, I had made some arrangements because I appreciate the importance of this, and perhaps we would have made our best effort at any rate. Now we've been waylaid, and the court understands the plan as I've laid it out to you, and I won't go into that here in open court. But what I indicated to you we want to do, I want to proceed, and I want to do that. The court had an occasion to speak with those two young men about these tapes and the sensitivity therein, and I have since our conversation this afternoon. Yes, the Messrs. Regwan and Schwartz, and in a kind of in-camera proceeding, and I have since talked to them also, and any protective order, I have absolutely no problem with one provision which I've asked them to include therein, and I think that'll be done. And I want to be able to proceed with our tapes, our copy of the tapes. The originals will be brought to this court. The people can do whatever they have to do. But this is not an issue where they have any standing at all. They can subpoena the two lawyers all they want. But the subpoena ducis tecum for these copies of these tapes are the fruit of the defense labor paid for by Mr. Simpson. He's the one who went to bat to uphold this court's order. And now that we're victorious, the people want to come in and try to get the fruits of this. And they don't get them yet. At some point, when Your Honor determines it's appropriate, then they'll be able to get it. And the court knows the other provisos that I've asked about that I will not go into now. But that's succinctly stated as the issue. I'd like to have my tapes. I'd like to have this over, and I'd like to be able to leave as soon as possible.
Mr. Roberts, you have the original SET for that matter.
Does the court, by the way, have an order from North Carolina? I gave the clerk of court.
It's here for
Good.
Did Mrs. Robertson indicate that she has the SCT, Your Honor?
No, she did not. My recollection is the original, since it was an out-of-state matter, was signed by the court with certain findings and transfers to the state of North Carolina.
That is correct, Your Honor.
All right, Mr. Darden.
What? Your Honor, I'm not sure what the arrangements were between Mr. Schwartz and Mr. Cochran, and I'm not concerned about those arrangements. Whatever contractual obligations Mr. Schwartz may have had to Mr. Cochran, they aren't at issue here before this court. What is at issue is an SDT, a court order, that the prosecution drafted and served on Mr. Schwartz. And in response to the prosecution's SDT, Mr. Schwartz came here to court and delivered those tapes to the court, so that now these tapes are under the court's jurisdiction. This isn't an impeachment issue or a discovery issue or a 1054 issue, and that is because these tapes are not in the defendant's possession. They're in the court's possession. pursuant to our SDT. If Mr. Schwartz or Ms. McKinney has failed to somehow respond accordingly or properly to the North Carolina court's order, that's an issue Mr. Cochran should take up in North Carolina or here in LA with Mr. Schwartz and Ms. McKinney. It's none of our business, just like our SDT is none of Mr. Cochran's business. But we're not here this afternoon to deprive Mr. Cochran of access to those tapes. We have no objection to Mr. Cochran having access to our tapes after we copy them. And we have someone upstairs right now who is ready, available, and willing to begin that copying process right now. If the court would kindly release our tapes to us so that I might leave. There is no provision under the law at this point that would require the court to surrender our tapes to Mr. Simpson or to the defense. As the court may recall, and I alluded to this morning, back on July 14, when we heard of the existence of these tapes, we came to the court ex parte and advised the court of what we had heard and learned about these tapes. And we asked the court for guidance. We didn't hide the ball. We didn't hide the fact of the existence of these tapes, if they existed, and we weren't sure, from the court, and we asked for guidance. The court directed us to issue an SDT for those tapes. We issued an SDT on Mr. Schwartz. He indicated to the court that he did not have the tapes. The court directed us to notify the defense of the existence of those tapes, and we did that. We have always operated from a position of fairness in this case, like in all the cases we prosecute, and we want to be fair again this afternoon. We'd like the court to be fair to us. There are tapes. We won't deprive Mr. Cochran of access to those tapes. I will take them upstairs. I will copy one for him and one for me, and I will return those copies delivered to the court today to the court forthwith. Mr. Simpson will get the value of his money and his dollar. The prosecution will get the value of its SDT. That's a fair approach, I think, to the situation. And I think we're being awfully kind this afternoon to offer Mr. Cochran a copy of our tapes. And I'm going to go out on a limb on this one, Judge, and I'm going to say that I'm sure that the Board of Supervisors won't mind springing for the cost of these tapes this one time for Mr. Simpson and Mr. Cochran. But this is unnecessary. This fight over these tapes is unnecessary. We don't want to delay this trial. We have a jury that has been sequestered for 7 months. We don't want to be in a position where Mr. Furman or some other witness is confronted with these tapes, and then we are forced into a position where we need to take days to review 15 hours, or 12 to 15 hours of cassette tapes. We like to move this case along. I don't know why Mr. Cochran doesn't want us to help him move this case along. The law is on our side on this issue, I think, and I'd ask that the court order the clerk to turn those tapes over to us. And you may order us to deliver a copy to the defense. They may wait with us, with our representative in the sound lab while those tapes are being copied. And one additional issue, it is our SDT to McKinney and Schwartz. They did not oppose that SDT. They did not move to quash the SDT, and Mr. Schwartz told the court this morning that he delivered the tapes to the court in response to our SDT and not in response to the North Carolina court's order. As I said before, the law is on our side on this issue. And we'd ask that the court direct the clerk to give us our tapes forthwith.
We're from the government. We're here to help you. Your Honor, let me make this as clear as possible. These are Mr. Simpson's tapes that he has paid for. These are the copies of the tapes that I arranged for, Your Honor. Yes, but Your Honor, how many times can I say that since they want to help me so much? These are the tapes that I went through. Where were they in North Carolina when the court ruled against us, when Ms. Clark was fighting me until the North Carolina Court of Appeals do it?
To counsel's characterization of my response. All I did was alert the court to the legalities of the procedure. That's all I did.
I said, where were they? That's all I said, Your Honor. And what I'm trying to say is that these are our tapes. Mr. Schwartz made it very, very abundantly clear. The tapes, the arrangements have been made to get the tapes here for us, for Mr. Simpson. The subpoena duca statement served last night, or when they were brought down here, was for them, not for our tapes. They cannot do that to the tapes that we're entitled to pursuant to the North Carolina court order and pursuant to your order. The originals of these tapes I have made arrangements for will be brought to this court by Ms. McKinney, and I've told the court when they would be here. That was the arrangement. Since she's our witness, we're the ones who would determine when we're going to call her, Judge, and that's the deal. Not what the people have tried to do by this preemptive strike. It's a real easy issue, as Mr. Darden said. I don't have any desire for them not at some point to have copies of these tapes, and we will do that appropriately as we've indicated. But right now, it's premature. These are our tapes, and I'd ask the court to resolve this matter right now. I'd like the tapes and the transcripts, and I'd like to comply, as I've indicated to you in 1054.7, with regard to appropriate copies. We want to proceed. Thank you.
Well, this is a issue of what came first, the chicken or the egg, since both sides were pursuing a discovery of these particular matters. The prosecution's effort to serve counsel, local counsel here, of Ms. McKinney was unsuccessful since counsel here did not have possession of the matter sought, the tapes and transcripts. The out-of-state process pursued by the defense was in fact successful, and the court has a copy of the order entered by the Honorable Peter Hugh, the presiding judge in North Carolina, County of Forsyth, directing that Ms. McKinney and her counsel turn over these tapes to the counsel for the defendant in this matter, Mr. Simpson, and this order was dated August the 8th, 1995, which predates the issuance of the SDT by the prosecution in this case. The court also, in issuing the SDT, the out-of-state subpoena ducis tecum, made a finding of materiality, and the matter was, as in the declaration in support of the SDT, indicated that these matters were for the purpose of impeachment. And at this point in time, I'm going to make the finding that the defense is under no obligation to disclose the contents of these tapes pending further order of the court. Since these tapes are here in the jurisdiction of the County of Los Angeles pursuant to the efforts of the defendant is entitled to the fruits of his labors and those of his counsel. However, as I indicated to you previously and to counsel for Ms. McKinney, I'm going to enter a protective order regarding duplication, dissemination, and publication of the tapes and the contents. Further, Mr. Cochran, I'm going to order that your office may not, that only yourself and Mr. Douglas shall have any access to these tapes other than the staff that you're going to use for your transcription. And those people will have to sign a declaration under penalty of perjury that they agree to the court's order, that they not discuss or otherwise disseminate the content of those tapes or the transcripts. And that order will be in effect pending further order of this court. Also, Mr. Schwartz indicated that he wanted to protect the proprietary interests of Ms. McKinney, and he would be forwarding to the court by facsimile a protective order, and I indicated to him my intention was to sign a reasonable protective order that he wanted to propose to the court on behalf of his client.
I also require a point of clarification.
Thank you, Your Honor. With regard, Your Honor, to this, I would ask that, and I have no problem with that, and I've talked to the court about the protective order and some specific language where I want one particular portion in there the court's aware of, that Messrs. Regwan and Schwartz said that they would agree to that without stating anything further on the record. The court is aware of what I'm talking about. The other thing is, because of, I would like and ask leave of court, because they're officers of the court, that my brethren, colleagues, and my sister, who's also not here, Sean Snyder-Chapman, also be allowed to have access to it. We will be governed by the same thing. They'll be kept in the office under those circumstances.
I would feel more comfortable with the order that I've made because it's two individuals in the same office. I don't want these things traveling around. Your lead counsel, Mr. Douglas, is in charge of discovery matters. That's why I selected you two. I'm not both of you, member because given the nature of this issue, I feel it's a reasonable order. And I expect you to talk about it.
All right, Your Honor.
All right, Mr. Darden, you wanted a clarification?
Yes, first of all, I am not aware of the content of this protective order that the court is apparently about to issue. and I want to make certain that there's nothing in this protective order that is going to preclude us from pursuing recovery of copies of these tapes from Mr. Schwartz or Ms. McKinney or by some other means.
When we receive the fax copies from the council, I'll share it with you before I sign it. If you have any objections or additions or corrections, since I asked council to propose it, since they are most interested in protecting the privacy interests.
At any event, so that is clear to Mr. Schwartz, the court isn't issuing any order that might preclude him from giving us a copy should he decide to do so.
No, not. That copy is here pursuant to the efforts of the request. All right. Ms. Sager, you got some burning desire to speak to the court?
Well, Your Honor, I have been advised that this morning's session included a discussion about calling my client Tracy Savage to the stand early next week. And that raised two issues. The first is a preliminary issue of whether there is anything that Ms. Savage can testify to that is relevant and admissible in light of Your Honor's order of yesterday. And we think that there is not, and there's no reason for her to be called to the stand at all. But in the event that the court disagrees and decides that there is something, and I should preface that by saying it's my understanding that there have been some kind of discussions, perhaps in chambers or off the record, and I'm not sure to what extent the prosecution has indicated its opposition to the defense and intention to call Ms. Savage and Mr. Bosco to the stand, but I have not been able to confirm that.
Let me bring you up to speed. The court's ruling yesterday was merely to indicate that your client, along with Mr. Bosco, were entitled to claim protection under the Reporter's Shield Law, and I found insufficient basis to go beyond the shield law and to pierce that shield. However, that does not protect your client from otherwise testifying to other matters that were published by your client. Whether those things are relevant, admissible, that's another issue that the prosecution has indicated that they are going to strenuously object to, and they're going to fight every inch of the way. Those matters have not been determined yet, and I suspect we will have a 402 hearing both with Mr. Bosco and Ms. Savage, and as well as perhaps other witnesses. And given the pace that we are proceeding with Dr. Baden, it looks to me like we won't see your client until next week.
Well, Your Honor, as to the first thing, that is how I understood the order from yesterday, but in making that decision, the order does describe whether or not the information is material to the defendant's case.
And there's a logical correlation between relevance and materiality. Is that the argument you're about to make?
Yes, Your Honor, and that's simply, when referring to the order of yesterday, that's what I was intending to mean, that given that ruling and the court's findings, that it seems to us that certainly a strong argument could be made that there is nothing left that Ms. Savage could testify to that would be relevant and admissible, and obviously I know the prosecution intends to argue that point.
Well, the defendant feels quite the opposite. They feel the fact that Ms. Savage made the publication that she did is evidence of something that they wish to present to the jury, and also they wish to present the facts and circumstances that led Mr. Bosco to comment on that situation last month.
No, I understand that there's a difference of opinion on that subject, Your Honor, and at least on this subject, we respectfully disagree with the defense counsel's position and find ourselves perhaps rarely on the side of the prosecution. We either seem to be on one side or neither side, but in this instance, we agree with them that this is not material or relevant evidence. But I understand that there is a dispute, and the court has not yet made a determination whether either Ms. Savage or Ms. Bosco have anything to say in front of the jury that is relevant and admissible. But in the event that the court is deciding those issues and makes a determination of admissibility that would require Ms. Savage to testify, there's a second issue, which is the timing of that. And I've already advised defense counsel of this, and they suggested that we come down here and do this on the record at the close of the session, which is why I'm here. Ms. Savage has long planned a vacation to take her out of state, and she has already left Los Angeles and is planning to be gone until the 20th of August, which would make her availability next week very difficult for her. And I have asked that if this issue is to be reached, that it be reached during the week of the 21st when she will be back in town. And I also have planned to be out of the country next week. And given those two factors, have asked the defense counsel whether this matter can be taken up on the 21st or any time during that week, and that both myself and Ms. Savage can be made available so that in the event the judge, Your Honor, decides that she needs to take the stand, she can be here and I can be here.
Problem is, she was released from this court subject to recall.
That's not clear from the record, Your Honor. At least she was released from this court, but there's nothing in the transcript that I could find that indicates that that was done subject to recall. But
Well-
even subject to that, I would ask, if the court determines that that's the case, that her schedule and counsel's schedule be accommodated to the extent that's possible, so that this matter not be taken up during a week when both of us had planned to be out of state and out of the country. And I understand that there's some difficulty in scheduling, but would ask, to the extent possible, that those things be accommodated.
All right, as far as scheduling, what's the position of the defense?
Well, Your Honor, thank you. Usually we're on the same side with Ms. Sager, and it is rare. We're the ones who asked to have her come down this afternoon. We had, as I indicated to you this morning, we had thought if the cross-examination of Dr. Baden never finishes, we wanted to put these witnesses up next. As I mentioned to you this morning, given 402 hearings, we wanted Kessler, we wanted Bosco, we want Savage. Next week, we want to finish our case, as soon as possible, and that's why we thought we should resolve this. So we'd like to have them next week if at all possible.
Well, you don't sound particularly adamant at this point.
Well, I'm adamant. Judge, I'd like to know that we're going to finish Dr. Baden tomorrow. If that happens, then I would like to call them on Monday. But it could be Tuesday, it could be Wednesday, but they would be the next ones up. That's what we're intending, Your Honor. Kessler, and then those two.
Well, we do have ahead of us a rather, what looks like an interesting legal battle over the admissibility of this material as well, so perhaps we ought to resolve that first.
Well, we'll be glad to do that, Your Honor, but still, again, hope springs eternal. We believe that we've had a 402 hearing, at least Mr. Bosco, and it seems to me that's not going to be a difficult issue for the court.
Well, yeah, the record is clear as what we're dealing with. So I think we could proceed with the 402 hearing without the actual presence of the two witnesses and their counsel. But do you want to accommodate Ms. Sager as far as the 21st?
May I have a moment? May I have a moment, Your
Yeah, I can also address the issue of scheduling.
Sure.
Honor? Can you talk to Mr. Sullivan? He may have a similar problem. Maybe we'll take them all up together.
Mr. Goldberg, what's the people's position regarding
Your Honor,
scheduling?
the people's position is very simple. We've already been heard 3 times on this issue. So has the defense. The court has already issued a ruling that this isn't material for discovery purposes. Materiality for discovery purposes is a lower threshold than the issue of relevance for admissibility in court. There is no way that the court can issue any other ruling based upon the rulings that the court has already done, other than finding
No,
that this is
counsel, I
irrelevant.
wanted you to address the issue of scheduling,
That's why, for the purposes of scheduling, Your Honor, we would like this matter also to be resolved expeditiously, and that means that we'd like it to be resolved, in all due respect to the court, right now. We don't see any reason why it can't be resolved right now. This is a very simple, straightforward issue, and I don't think anyone needs to be heard any
Another
further on it.
no-brainer, huh? All right. Mr. Sullivan.
Your Honor, may it please the court, basically I'm in a slightly different position than Ms. Sager because her client now is not here. My problem, unfortunately, is my client is here every day and can be called literally almost at a moment's notice. At some point, I have to return to Washington, D.C. What I find myself in need of is some degree of certainty. If we could take up these foundational issues, determine whether Mr. Bosco's testimony is indeed necessary, and then if it would be possible to get some kind of reasonable notice, if it turned out that he was going to have to in fact go on, then I could be prepared to be back here. As delightful as it has been, at some point I do have to go back to my office in Washington. I was only supposed to be here for a week originally. I've extended it because of these proceedings, obviously, but it would be helpful to know, what the deal is. So.
Sure.
I've asked trying to accommodate everyone. I've asked Mr. Douglas to see if he can reach Dean Ullman. What I would propose is that the court might consider resolving this matter and granting our motion to call these witnesses tomorrow. There'll be no holding of one's breath. And we can then, if the motion is granted, we'll then agree perhaps to call them on the 21st. Also, we'll throw our case off, but we'll try to rearrange if that helps out.
How does that impact Dr. Baden tomorrow?
Well, I'm at the conclusion, no, we don't want to take Dr. Baden off. I thought, at the end of the day, I was being optimistic that Mr. Kelberg might finish fairly early, to get an estimate on that.
Mr. Kelberg?
Your Honor, is the court day tomorrow to be a half day?
Yeah, we'll conclude at noon. I have medical appointments in the afternoon.
I can't guarantee that I would be done. I would hope to, but it depends on how responsive Dr. Baden is to the question.
Well, let's shoot for noon tomorrow, or 11:30 tomorrow for this hearing.
Let me see if the chair can be here. Well, no, he can't be here. This is his issue, Your Honor.
21st it is.
Wait, just one second. But I'm advised that Dean Ullman can be here Monday afternoon. What I would ask is, let's assume that in the best case scenario, Dr. Baden is finished by Monday afternoon. These are the next witnesses we intended to call. Mr. Bosco, and I think Mr. Sullivan is indicating, at least regarding Mr. Bosco, that might be, perhaps we can take that up on Monday. And maybe Ms. Sager could work something out. We can perhaps proceed in Ms. Savage's absence. We have someone here perhaps, and resolve it on Monday afternoon. That would be easier, and then if we can work on the testimony thereafter, if we're successful.
Your Honor, could we inquire as to what the nature of the hearing will be? Are we going to actually have testimony? If so, what would
No,
it be?
this is a legal argument only. I mean, the issues are framed.
So the legal argument is going to be, we're going to argue the issue of materiality again?
No, the admissibility, not materiality.
And the theory of that admissibility. Also.
Right.
So we understand you. And so I'm saying Monday afternoon might work out for everyone.
Could the court perhaps just frame the argument so that we know what we're going to be addressing it? Is the argument is
No,
immaterial?
well, counsel, we've discussed, as you said, we've discussed this 3 times before. They want to put on the videotapes of Tracy Savage making these reports. They want to put on Mr. Bosco to say, yes, the same misinformation came to him. They want to use that as evidence in support of their evidence tampering, their rush to judgment theory, and all the other arguments that
I know, I understand, Your Honor. I just want to know what we have to be confronted with, because we might like to brief it, or we might like to argue another time before
All right.
time.
Mr. Sullivan, are you available Monday?
Yes, indeed, Your Honor. I just have a commitment at the end of the week in Oklahoma, and another case Thursday and Friday. It would be
Right.
a
Monday it is.
hardship to...
All right, Monday, as far as Bosco, will address both issues since they're related. All right, what time do you want to do this Monday? First thing Monday morning? Monday at 1:30?
Monday at 1:30. I think jury, Dean Ullman cannot be here until Monday afternoon. Monday 1:30.
Monday at 1:30.
Well, Your Honor, I will be out of the country on...
I understand that, counsel. We'll take up, we have Mr. Sullivan. We'll take up the issues regarding Mr. Bosco, which is a related issue. It's all part of the same thing.
And if the decision is made that Ms. Savage has to take the stand, that will happen sometime after August 20th?
Yes, it will. All right, thank you very much. Anything else before we